trial, and it is very active litigation. And this is a point more often, you know, someone like Rachel and I, if you haven't involved them early on, most likely will get involved. And the reason why is because, to put it bluntly, litigation can be a part-time, if not a full-time job. And oftentimes, particularly with these deadlines, unlike in the agency process, they tend to come a bit more fast and furious in the litigation process. And that involves things like discovery, where you are, you know, essentially serving like an investigator and collecting information from the other side. The taking of depositions, where you're interviewing witnesses, and ultimately proceeding on to a full-blown hearing. So I think at that point, it is daunting, I would say, for people to approach that on their own. And so that's where someone like an attorney like myself or Rachel could be there to assist you. And now what that administrative judge is going to do is he's going to review all the facts and actually make a determination on the merits, determining whether or not you in fact have been discriminated against and what relief you'd be entitled to. And so once that agency, or I'm sorry, the administrative judge issues that decision, the agency actually implements it. And so they'll issue, you know, as we mentioned before, what's called a final agency decision, saying, you know, the administrative judge ruled this way, and here is our, you know, decision implementing that ruling. And they will also give you your appeal rights. So, for example, if you do not, if you don't prevail before the administrative judge, then the EEOC, or I'm sorry, the agency will tell you you have appeal rights. The first one is to the EEOC, and that's their Office of Federal Operations, where you are, it's like filing a brief in an appellate court. You have 30 days from the date you receive that decision from the agency to file a notice and letting them know you're going to appeal, and then another 30 days to file a brief in support. And now the agency will have an opportunity to respond to that brief, and then the commission will render a ruling based on those briefings, again, as to whether or not the decision below by the administrative judge or sometimes by the agency was incorrect. And this can be, unfortunately, a really long process. There is a major backlog at the EEOC, and this appeal process can take upwards of a year, if not longer. And unfortunately, both Rachel and I can tell you probably horror stories about cases that have sat at the commission. But, you know, there is that light at the end of the tunnel called filing in district court. So I'll turn it over to Rachel to tell you a little bit about that.
Sure, and I just want to touch briefly on when in the process you as a federal employee going through this federal employee complaint process have an opportunity to decide, you know what, I want to opt out of this process and try my luck in federal district court. There are a number of deadlines that you need to be aware of, and the first one is after you initiate your formal complaint, and if you recall earlier on we talked about a 180-day window of time that the agency has to investigate and issue a report of investigation on your complaint. So after that 180th day passes, you have an opportunity. If you don't want to, you know, proceed any further with the EEO process with the agency, you may file a federal court complaint that seeks relief, you know, through the federal district court process. And, you know, there may be many reasons why you choose to do so. Obviously, one of the key reasons relates to the right to be heard by a jury of your peers. That might be a factor that leads you to want to pursue litigation in federal court. Assuming that you move forward with your complaint and the agency issues what we've termed a final agency decision in your case, you then have a right to sue in federal court within 90 days of your receipt of that final agency decision, so long as you have not filed an appeal with the EEOC. If, in fact, you do file an appeal with EEOC, you have to wait a period of 180 days from filing that appeal, and you may, at that point, go back to federal court to file your court complaint there, assuming that no decision has been issued yet on your appeal by EEOC, which, as we've talked about, is probably going to be the case.
Yeah.
And finally, if you go all the way through that federal employee complaint process, and OFO, the Office of Federal Operations under EEOC, issues a decision on your appeal, and you disagree with that decision, now you have your final opportunity to go to federal district court. And be very mindful of the deadline. You have exactly 90 days from your receipt of that decision to go to federal district court.
And just one other thing about once you file that formal complaint, if you make an amendment to your formal complaint, that resets the clock. So it's after that last amendment. Or if it's been almost a year, 360 days, then you can file it any time after that point, the 360 days from the filing of your formal complaint. So we talked a lot today about the process and what some of the important deadlines are and what you need to be aware of as you walk your way through this process. But also one of the things we want to talk to you about is why use an attorney? Why get help from an attorney? I think there are a lot of main reasons. The first is recognizing and preserving your claims. I think an attorney can be a really good evaluator of the merits of claims, as well as to tell you how to develop the evidence to prove your claims. I mean, one of the important things I always tell clients, for example, is document, 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 because that is going to be one of the easiest ways to prove a claim of discrimination. Also, it's understanding exceptions to the rules. For example, we talked about the 45-day deadline in terms of initiating counseling. But with regard to a hostile work environment complaint, it's a little bit different. If you have incidents that occur over a year period, you just need one of those dates that occurs within that 45 days, not every single one. And this is another way agencies, if you're not familiar, will try and knock out your complaint. And they'll say, this isn't a hostile work environment. These are all separate instances, and they need to be dismissed because they weren't raised in a timely manner. And the next thing is trying to understand or sift through the agency's explanation for why they didn't discriminate against you. And so it's our job to try and prove why that's false or whether it's called pretext for discrimination. Next, it's negotiating with the agency in order to try and settle a case. I mean, the fact of the matter is that agencies have lawyers, and and they, I think, incorrectly or unfairly, I think they take advantage of pro se complainants all the time, and they think they can basically tell them that their case isn't worth anything. And so it's nice to have someone in your corner that can stick up for you and really argue the merits of your case in order to leverage a better settlement that's in your interest and not just the agency's. I think the next one, and again, beating this drum again, attorneys are critical in terms of ensuring timeliness. Because again, missing a deadline is the easiest way to get that complaint dismissed. And also there are a lot of very conflicting deadlines sometimes, particularly at the administrative judge level, in terms of the discovery process and raising, dismissed claims and, being able to sort through that is, I think, important. And finally, it's recognizing injustice. I think we can also identify when you're represented by counsel, or when the agency is represented, when they're trying to basically put one over on you. If they're asking you for documents that they're not entitled to, or they're seeking a remedy that's inappropriate, you need someone that can stick up for you. Because again, particularly when it's involved in disciplinary action, this is your federal career at stake, and you don't want to go in there, without some weapons and without someone by your side who can use the law to advocate for you and to provide you counsel as you maneuver your way through the EEO process. So we hope we've given you a good guide on what your rights are as a federal employee in the EEO process, and we hope that we've shown you a little bit about how an attorney can help you best proceed through that process. And what we're going to do now is open the floor up to questions and try and give you a little bit more guidance. And we would ask that you try and keep your questions, general. And if you have more specific ones, then, we can, talk to you individually, and we can set up a consultation. So
we received our first question, and the question is, when does the clock start? At the initial first contact, and what happens if I never hear back regarding the complaint? That's a very good question, and we've talked about a lot of different timelines here, but the key deadlines to be aware of is in terms of that initial time frame where you believe that you've been discriminated against. For instance, you've applied for promotion and you receive notification that your promotion has been denied. From that point in time, the date that you learn of that discriminatory action against you, then your clock starts running, and you have 45 days from that date to initiate your EEO counseling with the agency's EEO office.
And that actually, Rachel, that brings up a really good point, because it is not the effective date of an action with regard to the EEO process. It's when you had notice. So, for example, if you're told of a demotion, let's say, and that is not going to be effective for another 6 weeks, that clock starts the day you learn of it, not 6 weeks from now. And I think that's an important thing to know when you're, again, counting those days to when you need to initiate counseling.
And after that once you've met that initial 45-day window, generally speaking, your clock starts running for the further deadline based on your receipt of the document. So whether it's receipt of the notice of right to file, ending the informal complaint stage, or whether it's receipt, at the hearing level of the agency's written request for information. Generally, from that time point on, it's deadline to begin the next step begins with your receipt of that notice.
And then again, if you have an attorney representing you, that deadline is calculated from when the attorney receives the document, regardless of when you receive it. And so we actually have another question. Oh, and I think there's one thing we actually didn't address for the gentleman. So what if you never hear back? What I would say is, you still have your initiation the date when you initiated counseling, but you would absolutely need to follow up. Because if you don't, then it is still on you in terms of the prosecution of your EEO complaint. And, if you sort of forget about it, the agency is going to forget about it too. So that ties into, this next question. If the person you filed a complaint against is moved to another division while your complaint is outstanding, what happens? So I think this is another good question. This comes up a lot, or if people retire. If a client or if a manager moves to another division, so long as they're still a federal employee, that person can still be required to testify. And the important thing to know here is that while it might feel like I'm being discriminated against by my supervisor, Joe Smith, your complaint is against the agency that you work for. It's not against the individual supervisor. And in fact, individual supervisors can't be liable under Title VII. So in that sense, it doesn't matter if they've moved to another division. If they've retired and they're no longer federal employees, the complaint still moves forward, but the manager is no longer required to testify. And that's an important thing to think about when you're developing litigation strategy. And our next question is, why isn't the denial of a reasonable accommodation an act that creates a hostile work environment? Well, I think it actually can be. I think that, again, the idea is that the important question is it related to other incidents of harassment?
So, for instance, if you have filed a complaint that is based on disability discrimination and you're trying to engage in the interactive process with the agency, which happens after you've requested reasonable accommodation or placed the agency on notice of your disability, the denial of that reasonable accommodation might serve as a form of retaliation if you've already filed a claim of discrimination, or if you've opposed discrimination against you on the basis of your disability, what have you. So certainly that can be a contributing act in a series of events that you may allege constitutes a hostile work environment against you on the basis of your disability.
Absolutely, and unfortunately, I think the bar for hostile work environment claims continues to get higher every day. And so you really want to look at the totality of everything that's happened in the workplace when you try and assess the merits of a hostile work environment claim.
Okay, we've received another question, and that question is, after you file an appeal with the Office of Federal Operations, can you ever rescind? Now, it's interesting, and it depends on where you are in the process. Certainly, you have a right to withdraw your complaint at any time during the process. At any time during the process, you can decide that you no longer want to pursue your complaint. And that might be as simple as not filing that initial brief status.
Right.
The agency will take an action against you. The agency will take an action against you for failing to file your brief. Or alternatively, as we discussed earlier, if you decide that you no longer want to continue with the EEOC process, after 180 days you want to opt out and go to federal court, you can place the EEOC on notice that that is your intention. And that's another way of rescinding your appeal.
Okay. Well, our next question is another something that I get often, and I'm sure, Rachel, you do as well.